All right, good afternoon, folks. We are going to start, and hopefully Mr. Gray will just be here momentarily. Um, our topic for this afternoon's panel is segregation. Um, it's had in mind just a very quick story that I'd like to share with you folks. About 20 years ago, before I went into practice of law and teaching law, I was a middle school social studies teacher. And as a young teacher, once in a while, you don't put together your greatest lesson plans. And this might be one example of such. So I was going to teach about the different branches of government and thought to show the power, the majesty of the court, I would discuss Brown v. Board of Education. And so I waxed quite poetically, I thought, about the history and legacy of segregation and how finally the court, under Chief Justice Warren's leadership, responding to Thurgood Marshall's powerful, evocative arguments, finally made it the law of the land. Segregation was not lawful. And right as I finished those words, I cringed and hoped that none of my 100% African American students would recognize the incongruity of my statement. I really hoped they weren't paying attention. Of course, one student, not so shyly, raised her hand and said, "Mr. Cover, but we're all black." And we led into, as some bad lesson plans do, into a terrific discussion about some of the problems there. But as my 8th grade students so wisely observed, segregation persists. And indeed, following some judicially enforced desegregation, we're witnessing resegregation. Schools where more than 75% children receive free or reduced price lunch and are more than 75% black or Hispanic increased from 9 to 16% between 2001 and 2014. The most intensely segregated schools, 90% low income and students of color, more than doubled over that 13-year period. Today, we'll hear perspectives from a number of panelists on both the power of law in the form of pioneering efforts by Fred Gray and the limits of law by reluctant judges to bring about desegregation. And we'll see how segregation persists in the form of racism taking root in special education, both over and under inclusive designation of children of color. And finally, one interesting outgrowth of integration efforts, and one feared by Southern segregationists over miscegenation, has resulted in an increase in mixed racial relationships. Our panelists, in the order we'll hear from them today, are Wendy Parker, who, as the biography suggests, seeks legal solutions to inequalities in education and employment. She is the James A. Webster Professor of Public Law at Wake Forest University School of Law. Before teaching, Professor Parker litigated school desegregation cases, and before practicing law, served as a judicial law clerk for Judge Jerry Williams of the U.S. Court of Appeals for the Fifth Circuit. Our second speaker, Natasha Strassfeld, is an assistant professor at New York University Steinhardt School of Culture, Education, and Human Development. Her research has a primary focus on special ed policy law and parental involvement in the special education accommodations process. She teaches courses in education law and policy, poverty policy, and special education. Previously, she represented children and families as an attorney at Legal Aid of Cleveland and Legal Aid of Milwaukee. And finally, Kevin Brown is the Richard S. Melvin Professor at the Maurer School of Law, Indiana University, Bloomington, where he has taught since 1987. One of the founders of the Critical Race Theory Workshop of the People of Color Conference, Professor Brown is the author of 2 books, Race, Law, and Education in the Post-Desegregation Era, and Because of Our Success, as well as numerous other articles. He teaches law and education, race, American society and law, torts, and criminal law. I'll leave the floor to Professor Parker, and we'll then go in turn, hearing from each of our panelists, and then have an opportunity for questions and answers.
When recording, stand at the podium. So I will stand at the podium. So good afternoon, Case Western. It's delighted to be back in Ohio. Ohio has a special place in my heart because my 2 teenage children were born here 15 and 17 years ago. So it's always nice to be back in the Buckeye State. I want to give a big shout out to Chad Arison. He's done an excellent job of organizing this. I'll show you. I'll clap for him. But I certainly know that he has not done it alone, that many of you have helped him, and for that I'm very appreciative. It's been very smooth coming here. We had a delightful dinner last night, so thank you so much for the hospitality that Case Western has shown us. And thanks for Professor Eaton, who's not even here now, for inviting me to come to this conference. As soon as I saw the lineup, I was like, oh, me too? Yes, I will definitely come be with you. So this morning, Professor Carlin told me something that I didn't know about, but Professor Garrow was like, everybody knows that, that Chief Justice Warren, if he had to pick sort of his favorite child, would pick Reynolds, the voting rights case, Reynolds v. Sims over Brown versus Board of Education. I did not know that. And then at the end of that presentation, we heard, voting's under attack, our democracy is sort of going out the window. So how does that go for voting? Not so well these days, I guess. So that leaves us with schools. Mr. Gray, again, referencing Professor Carlin, like he's taking a shotgun everywhere, right? He's not just doing everything he can with voting rights, he's doing everything everywhere. So Mr. Gray also filed a school desegregation case called Lee versus Macon County. And so I want to talk about that case today and make a little bit of a plug for school desegregation. So I've got 3 things to do today. The first thing I want to talk about Lee versus Macon County, and my argument here is going to be that if school desegregation was ever going to be successful, it would be in Macon County, Macon County, Alabama. The second thing I want to talk about Alabama today, and things aren't so good in the educational system in Alabama. Surprise, surprise. And then the third part, to sort of talk about the why we have that disconnect. So in 1963 in Alabama, the schools were completely segregated 9 years after Brown versus Board of Education. Not a single white student attended an African American school, and not a single African American student attended a white school. So Mr. Gray represented, there are 12 of the 13 pictured here, 13 African Americans in Tuskegee, Alabama, which is located in Macon County, Alabama, who wanted to enroll in the white school. And here's Mr. Gray as a youngster. You too can be a young lawyer doing great things. He filed the suit, and other people have referenced this language he used in his autobiography because he's willing to destroy everything segregated that I could find. And of course, the schools in Alabama gave him a great place to do that. The great thing about Mr. Gray, and the great lesson, I think, of his legacy is, one, he's willing to file the lawsuit, right? He's willing to put himself forward, but he doesn't try to do it alone. And what makes Lee versus Macon County such an interesting case is you had so many lawyers throughout the United States saying, hey, I want to come to Alabama too and help you battle school desegregation in that state. So you had the NAACP, LDF, 2 very famous lawyers from that organization, Jack Greenberg, who we've heard about already this morning, who recently passed, and then a woman who eventually became the chief district court judge for the Southern District of New York, Judge Motley. Both of them came down to help desegregate Alabama schools. The United States got involved, the Department of Justice, Burke Marshall, John Doerr came down to sort of litigate this. HEW, after 1965, came down. Derek Bell, the author of these 2 books and many other books, came down to litigate school desegregation in Alabama. So you had these host of very talented, very committed lawyers, sort of a dream team, if you will, of lawyers coming to Alabama and saying, hey, we want to be a part of this battle. We want to help you integrate schools in Alabama. So you had this dream team of lawyers, and they were facing sort of this great judge. Judge Johnson, according to Martin Luther King, was a man who gave true meaning to the word justice, right? He was considered to be an avid friend of the civil rights movement. And his 1967 remedial order in Lee versus Macon County put him on the cover of Time magazine. Professor Fisk sort of gushed about this opinion. He said it was as ingenious, as path-breaking, as innovative as something like Marbury versus Madison. So this order that he came up with in 1967 was really groundbreaking in the school desegregation arena. Judge Johnson, I don't think he was on a power trip, but he just recognized how much segregation there was in Alabama. So in his 1967 order, he ordered 99 school districts to desegregate within 20 days, okay? So that's a lot of school districts, it's a short amount of time. He also said all the high school athletic conferences had to desegregate, the junior colleges had to desegregate, the trade colleges had to desegregate, and four-year colleges and universities that had not already started the desegregation process had to desegregate as well. So what you had in this order was, you know, really taking on Alabama and saying everywhere you've got segregated schooling, we're saying you can't do that anymore. You've got that backed up by the enforcement power of the Department of Justice. You've got HEW that now has access to funds to withhold from school districts if they don't do it. And you've got Fred Gray sort of marshaling the support of Tuskegee citizens and other Alabama citizens for this to happen. So at this time in Alabama, you've got everybody trying to get the schools desegregated except what? The state of Alabama, right? Because George Wallace took office a week before Mr. Gray filed this lawsuit. And of course, part of his inauguration speech is, you know, segregation now, segregation tomorrow, segregation forever, right, forever. So you had all these forces marshaling to fight segregation, but you still had the state of Alabama on the other side. That 1967 order, I think, was remarkable in many respects. But I think the case is also unique for what started happening in 1995. In 1995, throughout the South, you had a number of school desegregation cases that were still pending. Yes, 30 years later, these cases were still pending, still on the federal court docket, and they were languishing. There was very little court involvement. Judges Albritton, Judges Thompson said, well, let's not let these cases languish on our docket anymore. They issued show cause orders for their pending school desegregation cases, saying to the parties, plaintiffs, go identify places where there's continuing inequities, where there are continuing disparities. Bring those to my attention, bring them to the defendant's attention, and the defendants, you need to do what you can to do about those inequities to the extent practicable. So, because of the 1967 order was so expansive, the 1995 orders were expansive as well. These were orders not just getting at things like school building, integration. They went to many issues, including special education that we'll hear about in a moment. But I argue that Lee versus Macon County was sort of the best opportunity to find, you know, real meaning coming out of Brown because of the people involved and because you had sort of two times to create equity in Alabama in 1967 with that order, and then in 1995 with these show cause orders. Okay, so Macon County, Alabama, Tuskegee, the school desegregation suit, and now I'm sort of shifting to the second part of my discussion, sort of how things are going now in Alabama. Macon County, I would not say that the suit ended up as the individuals in that suit wanted it to end up. From 1963 to 1965, the school that the students were initially admitted to became an all African American school. I think the students who were seeking integration, they weren't seeking, you know, to get the white school all to themselves, right? They had already experienced segregation and found it lacking. What they were trying to do was to have an integrated school experience, but Governor Wallace gave white parents an exit ability, and they took it. So here's a picture, you know, from Tuskegee Public Schools. You'll see most of the faces on that slide are African American. The school board is all African American. The superintendent is African American. The student body is 99% plus African American. The teachers are over 95% African American. So I would argue that for Macon County, itself, Wallace's promise of segregation tomorrow actually has come true. And that certainly I don't think was the goal of the litigation. Part of Governor Wallace's battle against integration was setting up these segregation academies, where they were ostensibly private but funded with public money. One of them was Macon East Academy. Here's a picture from their website. That academy is a private school. It's still ongoing. And ironically, that's sort of the best integrated experience you now have in Tuskegee, because there are a few faces of color there. Okay, so that's Macon County, but this was a statewide suit, so I'd like to look a little bit about how Alabama is faring on issues related to school desegregation. So there are lots of ways to measure whether a school is integrated or not. Here's one way to measure, is to compare the African American population of the school for a typical African American student and for a typical white student. So in Alabama, the average white student attends a school that's 19% African American, and for the average African American student, that's 63%, that's a difference of 44. So you may say, well, all of our schools are segregated, right? We've got segregated schools everywhere. Cleveland's got segregated schools. Maybe your community has segregated schools. But I would argue for Alabama, they're sort of not doing well compared nationally. The national number is 39. And it's actually smaller in most southern states. Georgia, Louisiana, Mississippi, North Carolina, South Carolina, and Virginia all sort of have a smaller degree of segregation. I want to also talk about the decline in African American teachers. Judge Wisdom, who was on the Fifth Circuit when all of this was going on, a big pro-civil rights person, he said that the most difficult problem of the school desegregation process dealt with teachers. And the reason for that is if you had a black principal in charge of a white teacher, a black male teacher in charge of a white female teacher, lots of people that's going to get their attention. Or if you've got a black teacher in charge of a white student, that's going to get people's attention. So integrating schools by their faculty is having a power shift dynamic that was very sensitive. That's part of what's interesting about teachers. The other thing that's interesting to me about teachers is that most African American schools under de jure segregation were underfunded, were poorly maintained. So a lot of those schools got closed, and then black teachers and black principals lost their jobs. So the African American student population in Alabama has stayed fairly steady at about 34% since 1939 to the present. The number of African American teachers from 1939 to 1959 about mirrored that at 30%. It's now dropped to 20%. Now, of course, there are a variety of reasons for the decline in African American teachers, right? They have more choices of where they're going to teach than they did under Jim Crow. But I just pointed out because I think it's often a missing piece about school desegregation cases. Okay, so I also want to talk about the achievement gap. As you know, in our country, we have an achievement gap that has a racial angle to it. It's been part of our country for a long time, and it's continuing today. In the 1970s, the racial achievement gap was declining steadily and fairly rapidly. So the 1970s, we were doing pretty well on the racial achievement gap. In the 1980s and the 1990s, it starts to uptick a little bit. But starting in 2000, the racial achievement gap has been declining. Unfortunately, it's still very strong in Alabama. Just look, you can pick any data point. I just picked this one, 8th graders in math, and sort of the achievement gap there is 31. That is exactly actually what it is nationally, and in South Carolina, you also have a 31 gap. In Ohio, the number's actually 33, so Ohio's not doing as well as we are nationally on this, or compared to Alabama. But it is lower in a number of other southern states. Georgia, North Carolina, Virginia, Mississippi, Louisiana all have sort of a lower number. Okay, so I've talked to you about why I think Lee versus Macon County was sort of this great opportunity for creating equity in our schools. I've talked to you about how that's actually not happening so much these days. And now I want to talk about sort of why. Sort of why do we have that disconnect? And first of all, I just want to make sort of a plea on behalf of Brown versus Board of Education and maybe why you might choose it to be your favorite Supreme Court case, even if Chief Justice Warren is going to choose Reynolds. Schools are super important, right? Yes, it's important to vote. If I had to choose, I would want to vote, and I encourage all of you to vote. But the school system is part of creating so much disparity in our country, and it has such promise for rectifying so many ills. So why has Brown come up so short in so many ways in Alabama? We could blame the Alabama state leadership, right? We could say, hey, it's Alabama's fault. You started with George Wallace. You know, you've never been that committed to school integration. You've got the Alabama Private School Voucher Act, you know, that's allowing white parents, again, to leave. You could blame Supreme Court precedent, right? There are a number of Supreme Court cases that came after Brown that you could blame. And then you could also, you know, just blame litigation in general to say that litigation is not an effective means for bringing about social change. So I guess now I want to change what I was going to say earlier, like when I was planning out what I was going to say, I had this spiel about what I was going to say, but I want to address a different question that's come up in many of our conversations. So what if we didn't have any school desegregation litigation whatsoever? What if the Supreme Court stopped issuing school desegregation cases after Brown versus Board of Education? What if we sort of invested all of our efforts into grassroots or social movement change outside of litigation? And I would say, well, where are you going to place that energy, right? Are you going to do sit-ins at schools? Are you going to boycott schools? Right? There were some early boycotts of schools where African-American students were like, I'm out of here, right? This is the way you're going to treat me. I'm going to walk out. I would say putting that effort into voting so you can get representation on the school board might mean a lot. But I would argue that litigation itself offers quite a bit of opportunity to do something about school equity issues in our country. When you have a school desegregation litigation suit, the African American community, the Latino community gets two very important things. First of all, they get to be at the table when the decisions are being made. Yes, they can make decisions without them, right? Or they can whisper talk without them. But litigation, at least it gets them sometimes at the table where they're making decisions, and I think that's very valuable. Secondly, I think litigation gives plaintiffs access to information, right? Information is power. It's something you can use outside of litigation to create change, and for that reason, I think it's important as well. I said I had two reasons, but I really have a third. I think sometimes school districts want to do the right thing, but they need some political cover, and I think litigation can provide them to that as well. So I suggest to you that Brown versus Board of Education, of course, was rightly decided. We are not done with that battle. It's a very difficult road to create equality in our country, especially when white people don't seem to be that willing to give up sort of all the benefits they've gotten under a segregated system. So I'm putting in a plug for Brown versus Board of Education. I'm putting in a plug for litigation in my presentation. Thank you so much.
Good afternoon. It's great to be here with all of you today. And it's been a really well-run and interesting symposium. So thanks to everyone who planned it. So Brian Stevenson is the executive director of the Equal Justice Initiative, and he describes in his very powerful book, Just Mercy, A Story of Justice and Redemption, a meeting he had with Rosa Parks and Johnny Carr in Johnny's home. He describes a lunch where two formidable women were laughing, telling stories, and bearing witness about what could be done when people stood up. They were always so spirited together, he writes. Even after all they'd done, their focus was always on what they still planned to do for civil rights. Being here today in the presence of Attorney Gray has engendered similar feelings for me as I bear witness to Mr. Gray's incredible life and career. Like me, I hope all of you today have had time to consider all that remains in the struggle for civil rights as we move forward. The history of desegregation in the aftermath of Brown is a story of countermeasures of resistance by its opponents met in turn by continuing litigation. I won't repeat that history today. Instead, I want to focus on one particular response to the command to eliminate a dual school system that resulted in the internal resegregation of supposedly desegregating schools and that response's connection to special education. I will then explore the issue of disproportionality in special education assignments and the Department of Education's guidelines on disproportionality in special education. And finally, I will consider the implications of recent reconsiderations of the issue of disproportionality and suggest some ways in which we can better meet the goals of providing a free, appropriate public education for all students as required by the Individuals with Disabilities Education Act, or IDEA as we call it, and fulfill Brown's promise of equal educational opportunity. In the response to the mandate to desegregate, many schools implemented programs of assigning students to particular classrooms and particular curricula based on perceived ability. So this idea is sometimes called ability grouping, ability tracking, or tracking. And it's not a new concept, but many public schools had implemented such plans in the early 20th century in response to what they perceived to be the diminished abilities of newly arrived immigrant children. More schools adopted such plans in the wake of Brown, with the consequence of then creating internal segregation from classroom to classroom in ostensibly integrated fully schools. So African American parents viewed such assignments to a particular track with understandable suspicion. One such school system was the District of Columbia's, which faced the obligation to desegregate on the heels of Bowling v. Sharp. And the school superintendent, Carl Hansen, was an advocate of tracking, and he implemented a tracking system in 1956 that provided for around 3 to 4 tracks, depending on the school, for its students. Hansen's argument was that he was trying to deal with the legacy of a dual school system where certain children had been saddled with the consequences of unequal education by having the tracks. So the system that he devised tiered students from an honors track for college-bound students at the top rung to a special academic track at its bottom rung. And students relegated to the special academic track were described as slow learners, academically retarded, or stupid. Julius Hobson was a parent of 2 DC school children and sued the school system, its superintendent, and the Board of Education, arguing that the defendants had failed to provide a special and equal education to African American and low-income students. So this case makes its way to the United States District Court for the District of Columbia, where it was decided in an opinion by Judge Skelly Wright in 1967. So in his approach to the issue of tracking, he assumed that the defendants were acting in good faith without discriminatory intent. Nevertheless, while he rejected the idea that the tracking system was, quote, nothing more than a subterfuge by which defendants are attempting to avoid the mandate of Bowling v. Sharp, end quote, he also concluded that the system was tainted by racial considerations. So at the high school level, the special academic track emphasized preparing students for low-skilled vocational work in the future. Selection into one's track could occur at any level, but typically occurred in elementary school. So what that meant was once you were relegated to that lower rung, it was difficult to near impossible for a student to ascend to a higher rank or a higher track. So assignment to this track was also strongly correlated to racial and socioeconomic status. And many predominantly minority schools did not even have an honors track. And at the lowest rung of the special academic track, the disproportion was particularly stark. Judge Wright found that the African American students made up between 94 and 96% of the students that were on the lowest track, while white students made up the remaining 4 or 5%. So Judge Wright concluded that the version of ability grouping practiced in the DC schools amounted to the denial of equal educational opportunity to the district's poor and African American students. Hobson was decided before the enactment of IDEA, or as it was known in the 1970s, the Education for All Handicapped Children Act. With the emergence of special education, disproportionality in placements, whether overrepresentation of African American children in special education or in retardation classrooms, became an issue for African American parents. In addition, the issue as to whether or not African American children were placed in honors or gifted and talented programs also became a consideration. And there were, of course, reasons in the African American community to be quite suspicious of placements, given years and decades of evasion and internal resegregation. So parents challenging disproportionality in special education assignments often encountered difficulty overcoming the deference that courts gave to purportedly objective tests, assessments, and the professional judgment of schools and their experts and teaching professionals within those schools. Moreover, the disparities in assignments were often not nearly as stark as in other cases. So school systems that were already under a court's desegregation order were more likely to be found to have discriminated in their special education programs. And ultimately, the same issue arises in Lee v. Macon. As already mentioned by Wendy, the Lee v. Macon case began in 1963 with suit against one school board by parents and children who were seeking an injunction to prevent the Macon County School Board from continuing to run segregated schools. The case was expanded across the next several decades to include the Alabama State Board of Education and over 100 local school systems. In 1997, Judge Myron Thompson in the Middle District of Alabama called up 12 of these cases against local and school districts, stating that parties should move towards unitary status. During 1997 and 1998, the parties engaged in discovery and negotiated consent decrees. While the state was one of the defendants in each of these consent decrees, these decrees mostly address local level problems. However, in the course of the discovery produced in these cases, the plaintiff parties found that in all cases, there was an overrepresentation of African American students in the mentally retarded exceptionality category. We would now call that mental retardation, and underrepresentation of African Americans in the learning disabled and gifted exceptionalities. In some of these cases, but not all, there was also an overrepresentation of African Americans in what was referred to as the emotionally conflicted exceptionality. It would now be emotional disturbance. So the decree has 4 major components, which are actually really important to outline here briefly. So first, changes to policies and procedures in the pre-referral, referral, evaluation, identification stages were required. So that meant essentially we're really trying to sort of hammer home and fine-tune the way in which we identify kids for special education placements. And we're doing that in a more systematic approach as opposed to just identifying and then placing. Second, there must be extensive teacher training, and the state moved to implement extensive teacher training throughout the state regarding teaching teachers and administrators how to actually identify students, what characteristics of students are who have disabilities, with emotional disturbances as well, and what the purpose and significance of disability placement in special education was. And that also helps teachers get to this notion that special education is a placement, and it's important that we get that right before we decide to place, perhaps based on no evidence collected by the teaching professionals in that classroom or in that school. Third, funding for programs in the general education curriculum to address literacy issues and services for at-risk students was required. And then finally, extensive monitoring of each local educational agency by the state and by the plaintiff parties was also required. So this 4-component decree has become a model for addressing disproportionality across the U.S. And this leads me to the next segment of my remarks today. So we have a paradox here, a moment where our current law stands in contradiction to at least some of our objectives. Racial disproportionality in special education is quite illustrative of this. We have a situation where the civil rights response for one group of individuals, students with disabilities, has become a potential source of inequities for another group, students who are racial minorities, despite their shared history of struggle for educational equity. So this educational paradox exists between the heavy monitoring of special education practices and inequitable outcomes, and it raises questions about how practitioners and policymakers can better achieve equity through compliance with IDEA. So most recently, IDEA has been reauthorized twice, in 1997 and in 2004. The 1997 reauthorization gave states the authority to ask districts to adjust their special education practices regarding disproportionality. In 2004, however, IDEA had greater teeth because the states are now required, or allowed rather, to find that some of their districts have significant disproportionality. And if they have found that, then districts have to spend 15% of their federal special education money on early intervening services. Now, that money can't be used for students who are already identified as having a disability and also needing special education-related services. Rather, the money must be spent on children of a new generation who are in kindergarten through third grade. So to determine what counts as significant disproportionality, however, it's up to the state-level statisticians who are deciding what those cutoffs are. So each state has to be guided here in regards to what those indicators are. So using the IDEA indicators 4, 9, and 10, and for some of you that might be smaller, it looks bigger in person. So 4, 9, and 10 are the indicators under IDEA. They require states to monitor suspension, classification pattern, and placement patterns. And the state can then use its own threshold to alert the Office of Special Education Programs within the Federal Department of Education as to whether or not school districts within a state have exceeded a numerical threshold. In the case of determination of significant disproportionality, the state must review policy, it must set aside an amount of money for early intervening services, and then it must publicly report on those improved practices if a district has been found to be in violation of the disproportionality cutoff. And states must also monitor themselves using indicators that are both quantitative and qualitative in the hope that services are improved based upon a variety of measures as opposed to merely making your decisions based upon that one cutoff. However, in practice, what's happening across the U.S. is that in order to decrease the prevalence of disproportionate identification of minority students in special ed, the law allows states to police themselves by virtue of allowing states to use their own particular threshold indices for having rates that are significantly disproportional. The threshold indices can be based on several different types of ratio measures, which I won't belabor here, but essentially the risk ratio tells us how the risk for one racial or ethnic group compares to the risk for another comparison group. Generally, that other comparison group will be white students. So a risk ratio greater than 1 for a racial ethnic group indicates overrepresentation in special education placement, while a risk less than 1 indicates underrepresentation. However, states get to determine what constitutes significant overrepresentation here. And in regards to having a better sense of the number of children that are actually overrepresented or underrepresented, we have a system that allows for less clear understanding of that issue because states essentially police themselves. For instance, in a GAO report in 2013, the GAO report found that only about 2% of the nation's school districts were actually flagged for overrepresentation. And the overrepresentation was also only concentrated in 5 states. Second, I've contributed to a body of research that has found that instead of overrepresentation, minority children may actually be underrepresented as of now. This means that those children may be missing critical special education services that they have a right to under the law, and that might also be helpful to them in overcoming educational impairments. Even further, this line has found that factors beyond race are really critical here in determining critical in determining lack of access and signs of disparity. So these factors include things like parental educational attainment, birth weight of the child when that child is born, household income, geographic region. So in some ways, the new paradox here is in a different way than the paradox we saw in the 1950s and 60s. If we have students who are minority who are eligible for services and they're not being identified for fear that either a significant overrepresentation finding might flag an alert to the state, or that it's sometimes easier to actually under-identify so that you don't have to have a plan of action for those students, then have we provided them with an equal educational opportunity under the law? Now, the Department of Education has actually taken notice of this as a continuing civil rights challenge. The rulemaking process is currently underway in regards to figuring out how we can actually have a standard methodology that is uniform across states, so that we can identify what needs states have, we can identify which children are actually being best served, and we can also then move forward with next steps. That's not to say that there aren't limitations here. One of the criticisms is that in some ways we're ignoring, if you look at only at covariates that in regards to whether or not a child is impacted by race or race and something else, sometimes the criticism is that that means that you're actually denying that there's a problem that exists. There is a problem that exists in regards to disproportionality and representation. It might look slightly different than what we thought it would look like, or that it looked like 20 years ago. It also does impact the type of work that we can get out of policymakers in regards to figuring that question out. If we have a different threshold that's measuring something that's actually not necessarily the problem, then that means that we have a solution that doesn't necessarily address the issue. So there's a continuing base of research that needs to be done in this area. But in some ways, I wanted to sort of close by thinking about where we started. I began with Brian Stevenson's story, his story about sitting in the presence of Rosa Parks and Johnny Carr talking about what is left to be done. And I think my story also takes us back to that place. The landscape of disproportionality has become very complex, but the work to both guarantee a free, appropriate education to all and to ensure equal educational opportunity continues to challenge those of us who are carrying on the work that was started by Fred Gray and so many others. So thank you so much today.
Thank you. I want to follow the other speakers and thank both the organizers and also talk about a great honor it is to be here at a symposium honoring one of Case Western's most illustrious alumni. He's always been a personal hero of mine. I'm on a panel that's discussing desegregation. And I could talk about the impact of school desegregation litigation on the integration of public schools in Alabama, as well as in the country at large. But this is a familiar story. You all know that the scope and the extent of school desegregation is a product of Supreme Court decisions and other major federal lower court decisions in this area. So to tell the story of school desegregation, you engage in a discussion of the impact of these decisions. But as the Supreme Court giveth, so does it taketh away. Thus, a discussion of school desegregation is typically a discussion about the rise of school desegregation and then the fall of school desegregation. And that leaves proponents like me of school desegregation after this normal discussion feeling dejected, head down, shoulders bent, cursing the lack of vision and justice of the members of the Supreme Court. Well, rather than do that, I want to return to the historical crossroads of the early 1960s, the time when Lee versus Macon County was filed, with the aim of identifying and marking out a path of an underappreciated aspect of desegregation in American society that may in fact prove to be much more significant and certainly more long-lasting. In this journey back, I want to bring us back to the intellectual space of 1963. Remember, this is the time of the bombing of the 16th Street Baptist Church in Birmingham. This is a time before the Civil Rights Act of 1964, a time before the Voting Rights Act of 1965, before the Black consciousness movement, before the Afrocentric movement, before the diversity movement, before the inclusion movement. This is a time when people of African descent were called coon, darky, or even black as an insult, and Negro as a term of respect. And yes, this is the time of the aftermath of the brutal murder of Emmett Till for whistling at a white woman in Mississippi. Today, when we talk about segregation, we typically divorce it from the primary motivation for it. And that primary motivation was the prevention of interracial sexual relationships. For as one 1867 Pennsylvania Supreme Court decision upholding a segregation policy in transportation put it, from social amalgamation is but one step to illicit intercourse and but another to intermarriage. But one of the most stunning developments in American society since Fred Gray filed that suit in Lee versus Macon County has been the significant and substantial increase in both interracial sexual relations involving blacks as well as black multiracial children. In other words, while racial segregation has not been conquered in our public schools, the most powerful underlying rationale for it has been obliterated. If we go back to the early 1960s, in some 20 states in the United States, marriage between blacks and whites was illegal. Indeed, of the 12 million blacks that existed in the country at that time, 12 million over the age of 15, less than 0.5% was married to someone white. But we began to see these steady increases in interracial marriages involving blacks, as you can see there, from 1960 to 1970 at 1.1%, to 1980 at 2.4%, jumping down 2010 at 9%. And indeed, the more recent the marriage, the more likely it is to involve interracial mating. So according to a 2015 Pew Research report, looking at 2013, almost 1 in 5 blacks who married outside of the race. And indeed, it was 1 in 4 for black males. Now, also, American society has witnessed a significant and substantial increase in the number and percentage of black multiracial children. In 1963, simply put, there was no such thing as a black multiracial child. You had the one-drop rule that was in effect, so 1 drop of black blood made a person black. Indeed, race was a socially ascribed characteristic, so it was not a matter of personal identification. But since 2000, we've allowed individuals to self-identify their race. And if you go to 2000, or the 2010 census, 7.4% of blacks indicated black in some other race, which is a 50% increase over what the 2000 census said. If we look at census data from 2012, as you can tell, the younger blacks are, the more likely they are to be mixed race. So as you can see here, while we're talking about those ages, currently ages 24 to 28, only about 7.9% are mixed race, but among blacks under the age of 5 up to 8, it's 19.1%. Indeed, the younger, as I said, blacks are, the more likely they are to be mixed. I want to now go back to the historical justifications against interracial sexual relationships in order to show you how much our society has changed since the 1960s. In colonial and antebellum America, there was a need to maintain the race-based system of slavery. And because of that, it was necessary to also prevent mixing of the races, because mixed race people threatened a race-based system of slavery. But beyond that, there were also serious religious justifications, not only for slavery, but also against interracial sexual relations. Racial inequality was not deemed to be morally reprehensible, rather, it was a manifestation of the will of God. And racial differences were viewed as immutable and eternal. There were two basic stories that came from the Bible that justified the notion that blacks and blacks alone should be enslaved. One was the curse of Ham, placed on him by his father Noah, where Noah curses his son Ham because of an indiscretion against Noah, that the descendants of Ham would be the servants of Shem and Japheth. The second story from the Bible was the story of the murder of Abel by his brother Cain. As a result of that murder, God placed a mark on Cain. Many felt that the mark that God placed on Cain was black skin. Now, a lot of people would combine these two parables together, and they would say that the black race was a descendant of Ham and of Cain. Thus, from Cain came the black skin, and from Ham came the curse that blacks would be slaves. There was also the Old Testament story of the Tower of Babel, where the reason we end up in separate continents is because God did not like humanity coming together. Therefore, God scattered us unto the different continents. So these were the stories that were generally seen as against the notion of interracial marriage. And prohibitions against interracial marriage and mating are the longest running statutes in American history. You can go all the way back to 1662 with the Virginia House of Burgesses that adopts the first anti-miscegenation statute. And indeed, in 1691, Virginia adopts a statute that banishes from its colony any free English or white person, or man or woman, who marries a Negro, a mulatto, an Indian man or woman, bound or free. Indeed, in the preamble to that 1961 statute, it made it very clear what the purpose of the statute was. And that preamble said the purpose is for the prevention of that abominable mixture and spurious issue, which hereafter may increase in this dominion. So the statute left no doubt that the purpose was intended to prevent multiracial children. Now, by the time of the signing of our Declaration of Independence, 12 of our 13 colonies, all except for South Carolina, had banned interracial marriage. And indeed, as late as 1950, 30 states still ban interracial marriage. And the religious objections to interracial marriage and sexual relations continued all the way through the Civil War up through the 1960s. Indeed, if you go to the main case where the court's going to strike down miscegenation statutes, which is Loving versus Virginia, the interracial couple there, Richard and Mildred Loving, were convicted of violating Virginia's Racial Integrity Act. And the trial court that issued that conviction justified his decision by saying, quote, "Almighty God created the races, white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with God's arrangement by man, there would be no cause for such marriages. The fact that God had separated the races shows that he did not intend for the races to mix." But as America moved into the latter decades of the 19th century, preventing miscegenation was increasingly justified by new scientific rationales of the need to prevent the negative consequences that come from the production of mixed-race people. Up until the 1840s, the dominant scientific view about the origin of the different races was rooted in the Bible. And according to Genesis, all humans descended from Adam and Eve. One of the strongest justifications then for all of the races being of the same species was also the notion that they could reproduce, and more importantly, that the progeny could reproduce. Well, this traditional monogenesis scientific view came under challenge in the 1840s. A different school of thought argued that humankind originated as a result of different acts of creation in several different places in the world. Josiah Nott, a Southern surgeon from Mobile, Alabama, published a very influential but short paper in which he challenged the fundamental beliefs of those monogenicists. Nott argued that mulattoes were a hybrid, that is, the offspring of two different species, like a mule is from a horse and a donkey. Refuting the notion that hybrids, that is, those of two different species, could not reproduce, what Nott said instead was no, mulattoes would simply be less fertile and inferior to full-blooded blacks. Nott went on to say that mulattoes therefore are going to have shorter life expectancies than either blacks or whites, that the women will be feebler, they'll be better breeders because many of their children will die early in childhood, and it will be difficult for them to conceive. But worse yet, Nott went so far as to say successive generations of mixed race people will be increasingly more degenerate. So the problem of interracial mixing in the first generation will manifest itself over several generations into the future. Concerns about Nott's scientific argument were taken so seriously that the census added a mulatto category in 1850 for the first time. And indeed, at least one mulatto category shows up on the census from 1850 to 1920. The Civil War then turned out to be a watershed for scientific research into racial differences, because what it did was to provide a mass number of people that you could do scientific research on. So the first mass studies of racial differences that included mulattoes comes out of the Civil War. And basically those studies showed on several different measures, including head size, weight, height, lung capacity, heart size, kidneys, and stomachs, that whites were bigger than blacks, but blacks were bigger than mulattoes. So from this evidence comes the conclusion that mulattoes are physically inferior to blacks. As for intelligence, the work of Dr. Sanford Hunt, who conducted 405 autopsies on dead Civil War soldiers, 381 of which had some black blood, established the mental superiority of whites. Hunt weighed the brains of full-blooded blacks and full-blooded whites, and of course found that the brains of full-blooded whites were substantially heavier than the brains of full-blooded blacks. But he did more. He also weighed the brains of people who were 3/4 white, 1/2 white, 1/4 white, 1/8 white, and 1/16 white. And what he found was that those who had 3/4 white brains were closest to whites, significantly heavier than blacks. Those who had 1/2 white blood had brains slightly heavier than blacks. But those who had 1/4 white, 1/8 white, and 1/16 white had brains that were smaller than full-blooded blacks. Indeed, the highest percentage of exceptionally small brains were in those who had 1/4, 1/16, or 1/8 white blood. So Hunt's conclusions were, quote, slight intermixtures, sorry about this, guys, I missed this one. Slight intermixtures of white blood diminishes the Negro brain from its normal size, but when the infusion of white blood amounts to 1/2, it determines a positive increase in the Negro brain. So his study seems to also justify the notion that the detrimental effects of miscegenation would get worse over the generations. Now, when you add this kind of evidence to the development in the late 19th century of neo-Lamarckian theories, which were developed from the early 1800s, John Baptiste Lamarck uh, proposed a theory that there was an unconscious striving in organisms that attempted to improve their species. This striving manifested itself in the male of a species trying to improve the species by mating with the best female possible. So in the late 19th century, in this pro-Darwinian space, what that meant was that black males had a natural desire in an effort to preserve, to improve the species, to mate with white females. This was a natural impulse that society itself had to check, and hence lynchings became a main way to do that. While no doubt many of the lynchings of black men were motivated by other reasons, the most common justification given was to check the uncontrollable sexual drive of black men towards white women. So if we now sort of, in conclusion, if we go back to the time of filing of Lee versus Macon County, there's no question that we have seen tremendous developments in terms of race in our society that point to this being a much better world than what we had in the 1960s. Blacks run Fortune 500 companies. Black music is universally accepted. There have been so many USAs and Miss Americas who are black that it's not even a news story anymore. We are amazed at how much money black athletes are paid. There's so many high black elected or federal officials, and of course, the President of the United States has been elected who is black not once but twice. Now, I'm not saying this with rosy glasses on, okay? I know about the problems. So I concede the negative in order to focus our time on the positive. And that brings me back then to school desegregation. Because when we compel black and white children to go to school together, it was obvious that we would see an increase in interracial sexual relationships in our society a generation later. Since human ideas like segregation take on a life of their own, that means it takes a conscious effort to disestablish its hold on our society. Desegregation of public education was that conscious act. And in increasing interracial sexual relationships and black mixed race children is also the most lasting effect of school desegregation. Because after all, isn't the natural conclusion of integration at its most fundamental level the production of mixed race children and interracial relationships? Thank you.
We have time for about 15 minutes of questions. Less than that. Down in the front. Oh, is Mike? Okay, Mike.
Oh, thank you. I had a question for Dr. Stransfield.
It's close, you know?
I'm scared. I'm sorry. You had mentioned something about the states had special education funds that were available.
Right.
Now there's a controversy, I guess, nationally about charter schools.
Mm-hmm.
Now, if any, as relates to states, how much is that money for special education been set aside for charter schools, as regards to special education, and how is that impacting the local public schools?
That's a really great question. First of all, can you hear me? Is this, no? I have the green light on. Thank you. Better? No? Oh, I'm sorry. Okay. So there are a couple of answers out of that. So first of all, if you have a charter school that is a public charter, then that's different than a sort of straight charter school. And the one difference here to remember is that in regards to IDEA, it applies to public schools. So charter schools don't receive, for the most part, they don't receive funds under IDEA. And they also don't have to adhere to it. So it doesn't mean that if you have public education services, special education services in a public school, and your child transfers to a charter school, doesn't necessarily mean that their IDEA funds travel with them, or that protections travel with them, services, any type of accommodation. So in some ways, it's sort of hard to make comparisons as to what the response for disproportionality is in a charter school. And the other thing in regards to charter schools is that it's very important to remember that they can actually kick kids out who don't necessarily perform academically to a particular standard. So disproportionality becomes more fuzzier as a concept in regards to thinking about charter schools. That also brings us back to thinking about educational opportunity, because does that mean that a child who has a disability can't go to a charter school that might be better than their public school? It's rather complicated. Does that answer your? Okay.
Thank you. This is to Professor Brown. So you were saying that kind of what we see is like a changing culture. So in the U.S., typically, if you're a small percentage of black, basically you identify and you're perceived as being black. So do you see when people are marrying, as you said, outside the race, does that change the culture, or does that in effect just create more people that we see as black? So is there any change that way? For example, in Brazil, I know they have all these categories that you can identify as, and here it's black or white, you know?
I don't think we're going to go that way, but you know, if you go back to the 1960s, you were either black or white. 99.4% of Americans on the 1960 census were either black or white. And with the one-drop rule, it meant if you had any amount of color in you at all, people assumed you were black. Today, when you look at immigration from Latin America, from South Asia, from the Middle East, multiracial kids, there are a lot of people in our society who run into that constant question, what are you? Right? It doesn't happen to me, it doesn't happen to Wendy, but there are a growing percentage of the American population where people are being asked, what are you? That means that those people have some control over their racial and ethnic identity, because they have to respond to that question, and it's up to them to decide how to respond. What American society, therefore, is doing is it's shifting from race being an immutable characteristic to race becoming a product of choice. And everything, all of our writings about race presuppose that it's immutable. American society is moving to a place where our fundamental ideas about race simply will not apply.
I would suggest that 4 generations of Filipina, Japanese, Korean, and Vietnamese brides did a great deal to blur the color line, culturally probably more strongly than anything done by the courts. Back down in Columbus, they're going to be playing South Pacific again.
And just along that, my understanding is Justin Bieber usually identifies as black on forms.
Really?
Yes, because he identifies more with the black culture and black music. He's been teased about it a little bit.
I had a question actually to follow up on Professor Parker's sort of question, and this is for all the panelists though, sort of what if we didn't engage in this litigation, I guess. And one question I have, or theory might be, to what extent do you see, at least in the last 25 years or so, the ed reform movement, however you might define that, as filling that void, or at least one attempt? And I just love all of your thoughts on how you characterize the ed reform movement.
I'll start. I think ed reform has a lot of promise, but we always let whites out. So whatever our current sort of educational reform movement may be, like now it's a lot of choice, like choice is sort of our way to create a lot of equity in our schools, but we're implementing choice in a way that lets white parents sort of exit out. So I consider it to be this continuous, systematic way of letting whites sort of separate as much as they can in our increasingly multicultural society.
I'll let you, because if I answer that question, half the people in the room will get up and say, I can't believe you said that. Well, okay, only because I'm forced. It's something that we've known for a very long time. We've done educational reform for at least 50 years. It seems to me that the basic problem is something that's rather obvious. How do you produce the same kind of education for low-income urban kids that middle-class suburban kids have, given the fact that most education takes place outside of public schools? That's really where the problem is. Kids are spending 75% of their time outside of the schools, and they're learning a lot there. So what we're asking our schools to do is to overcome this tremendous deficit that low-income minority children have simply because they were born to the wrong parents. So our educational reforms have gone on. We've known this problem for 50 years. We've yet to find a silver bullet because what we're trying to take out of the mix is this tremendous influence that parents have on how much their kids learn. If we were really serious about education reform, we'd be talking about boarding schools for low-income urban kids. And you have two public boarding schools, one in Washington, D.C., one in Baltimore, Maryland, that have shown some effect in improving the education of the kids. But the problem is boarding schools in the United States cost too much money. People are not prepared to put out $40,000 per year for poor urban kids. So we'll continue to tinker with educational reform. We've done it for 50 years. We'll do it for another 50 years. But you'll still see significant gaps.
So I think I agree with many of the components that each of the other speakers has stated. I disagree with some components. I'm a special education person, so I think in regards to the expenditures, what we know about the budget for most districts in most states is that special education is the most expensive endeavor that a state can engage in. It costs a lot of money to properly educate kids, particularly those with disabilities. In regards to education reform, however, it's been something of a mixed bag. We have laws that protect kids with disabilities. We have laws that are designed to sort of monitor disproportionality to make sure that these things are equitable. In practice is where things get really hairy. I think that litigation has really done a great job of moving the needle, but there's a long way to go here. I think parental involvement is something I care very passionately about in regards to my own research. I think it's critical. I think that one of the things to sort of to go back here on is that in regards to thinking about what we've done for 60 years is that we've tried a lot of things and we don't necessarily always adhere to an evidence base. And that really does impact where our dollars go if we don't look at practices that are evidence-based and that are really sound and that are going to work.
For forced. Our notion was actually was actually to put them overseas. So to take the kids out of